the opposing experts, to learn what the opinions are of the opposing expert, to prepare for trial. And the rule in question is MCR 2.302 is entitled General Rules Regarding Discovery. Subsection B governs the scope of discovery, and the part pertaining to expert witnesses is subpart 4, and it's entitled Trial Preparation Experts, and it gives us the right to take the deposition of the opposing experts in order to prepare for trial. One of the problems that happened after our court rule was amended to include that language, or actually created in 1985, was some of the attorneys on the other side, after discovery deposition was taken, would then say, well, I'm going to be reading this into the record at the time of trial. Or after I finish my cross-examination of the expert, they would start to qualify him and ask them their own questions, and which would create an objection and say, look, we're taking this for discovery purposes. The issue came out pretty quickly. 3 years after the court rules were created in 1985, the 1988 case of Petto versus Raymond
abrogated the rule.
Or interpreted it in a slightly different way.
It couldn't possibly.
Pardon me?
It couldn't possibly.
Well, I think...
I mean, the rule makes it quite clear there is no right to a discovery-only deposition without stipulation or court order, right?
No.
That's not what it says?
Well, it says we have a right to take the discovery deposition to prepare for trial. There's another rule that says if we want to limit a deposition in its purposes for discovery only,
yes,
we can ask the court for protective order.
Correct. Otherwise, you are subject to the rules that any deposition has, including it being used for impeachment or anything else.
Right.
If you want it limited, you have to get a court order or stipulation.
Which completely abrogates the purpose of the rule and its title.
It's a
if
process.
the title of the rule is to prepare for trial, and those are the two tools we have, interrogatories and depositions, of what use is it if we learn the opinions at trial?
I've not yet understood what the burden is of having either to get the stipulation of the opposing counsel or the approval of the court to limit the discovery deposition to the purposes of discovery only. What is that burden?
I anticipate that the other side, I'm a defense attorney, and the plaintiff's lawyers that we face don't like the idea that we can go out, take their expert's deposition. So I expect opposition. I don't expect stipulation.
I understand that. But you still have a court, a judge, who you can say, Judge, we want the ability to understand what this is about without being subject, having this be a deposition for all purposes. And you anticipate that the judges of this state will be unsympathetic to that plea. Is that what you're saying?
Well, if we alter the rule to indicate that you need to get the judge's permission or stipulation first, it's already a matter of discretion. But if you take away the existing case law, which says the way the Court of Appeals read this rule is that the defense has a right to take the discovery deposition of the opposing expert. If the plaintiff wants to use it for trial purposes, he has to notice it as a trial deposition. And if the defense doesn't like that, I'm just using defense because it fits me that way, we can file a motion for protective order asking the judge to limit it for that purpose. So Petto interpreted this rule 3 years after it was created. We've been practicing that way since 1988. We didn't think the rule needed to be fixed, but the court correctly noted that the rule and the practice are not a perfect fit. And so I drafted a rule that adds a single sentence that makes it clear that we can take a discovery deposition to be used for purposes of discovery and impeachment only without the necessity of a protective order.
So the answer to my question?
The Chief asked you about trial judges being unsympathetic to this request, and it's been a long time since I was in a court to make such a request. But what I recall is that if the expert was out of state, then yes, the trial judges were very unsympathetic because of the cost of either going there to do it or bringing the expert in. And my question to you is, has that changed? When the expert is an out-of-state expert, which more often than not, that's what you have in many of these bigger cases, are the trial judges reluctant to give you a discovery-only dep?
No, because of the Petto case, which interpreted the rule to provide that I have that right and that plaintiff cannot read it, absent the plaintiff, in my case, filing a motion for protective order or actually filing a notice to take the same deposition for trial purposes. I file my notice, then he files a notice for trial purposes as well, and if I don't like that, I can oppose it. So that has been the way the law has been followed since 1988. The court is absolutely right. There's an ambiguity in it. I think we correct it with the addition of that.
So your best argument is to do nothing, isn't it?
That was our original argument. The court asked me to try to make the rule match the practice so that the practice matches the rule, and one sentence addition does it, I think.
All right, thank you.
Thank you.
The next.